Hey.
All right, we are live, and before we get rolling, I wanted to tell everybody what happened. You may notice that last week's live stream doesn't exist.
Ooh.
Well, it appears that we have angered the gods at YouTube, supposedly with medical misinformation, which we were not talking about. We were covering an article about how exhaling can destroy the environment.
Yeah.
And Viva Fry brought up Bill Gates. I went into the population shrinkage philosophy of WEF and other people. And Viva Fry went into Bill Gates and some things he talked about in a TED Talk. Supposedly that was medical misinformation. The clip that we put out of that segment got removed. The show itself got removed. There's a warning on this channel. Next hit, it'll be suspended for a week, along with America's Untold Stories and Eric Hunley, if we're going by YouTube traction. So, folks, it really does help. Any support you guys have, consider following me on X. This is on X right now. If you want to watch the uncut version of last week's show, it's on X, it's on Locals, it's on Rumble, it's all over the place, and I really, really do appreciate it. I'm hoping everybody here will retweet out today's show because you might be watching this on X yourselves, but I am a little bit pissed off about YouTube doing that, and then I had to go through the training about medical misinformation, which, by the way, is some of the worst training possible. I don't get their convoluted object. I got half of it wrong, because it's very confusing. They're like,
I just did the training this morning because I posted like a 40-second clip of like, well, if you have, like me thinking like the internal workings of my mind, and apparently it was too graphic for YouTube, and they pulled it down overnight and then sent me all this training that I had to go through.
Yeah, I have to. I'm going to fight it. Put the clip up on X. Bug Team YouTube, see if they tell me to pound sand. I don't know. Dave, did you do the appeal, which comes back in 20 seconds?
In 20 seconds. Oh no, we reviewed it. Oh, you couldn't have reviewed it. You could not have. So I sent in the appeal. Yeah, it was like a minute later. Not even.
Yeah, it's ridiculous. It's like, I don't even know if we have time for the email to refresh. And then you go look on there and you're like, well, that's funny. Because when the clip is unlisted, I didn't even have the clip released when it got yanked off. Mm-hmm. So it was unlisted, and there was only one view on it. And then they review it. There's only one view. Interesting. How's that work? So
yeah, I don't know. It's automatic. And so, but I appealed, and I said, this is creative artistic license kind of thing, right? Mm-hmm. Like I'm taking these clips and I'm using it as an artistic means to express, the thoughts that go on in someone's head for a few minutes. And they didn't look at it at all. Immediately it was like, nope, still doesn't justify it.
Yeah. It's have you guys run into this yet? Steve, Ian?
Oh, I had one where they, so it was talking about the Leonard Couch shooting. And they initially took it down, not for the violence in it. They took it down for glorifying drug use, because I had made some comments about his behavior being erratic, and maybe there was some drug use, or I don't know. Like, we'll have to see what the reports are and so forth. But certainly the officer might have been wondering about that. And so they're like, well, this glorifies drug use. And I'm like, how? The dude literally dies. How is that glorification of drug use? So they took that down, and then they said, you can't show gore. And I was like, well, there's not a single spot of blood visible in this. You can't actually see anything at the moment of the shooting, but I still blurred it. Mm-hmm. And they're like, yeah, no, you can't show videos that emphasize or like linger on the gore. And I'm like, it doesn't do that either. And then they keep coming up with like new and zanier reasons why it can't. And then finally, when I submitted that, they said something along the lines of, you know, if you keep objecting to this, we might ban your channel or something. And I was
Oh, I
like,
love that.
Yeah.
I was like, all right, YouTube, if you're gonna threaten me over this one, like whatever. But like,
Did you publish that? No, I mean, that's something that you really need to screenshot and then put that on X and everybody else saying, this is how YouTube negotiates. Thank you, Team YouTube, because that needs to get out there. I mean, they're literally threatening you. They have a supposed appeal process you're using, and they're like, well, if you appeal too much, we're going to get tired of you, and we're just going to yank you.
Yep.
yeah, I'm just like, is it worth it?
Well, that's what they count on. I mean,
that's what I screenshotted it and published it on X. I posted it out there. I didn't post the immediate reply I got when I tried to appeal it 30 seconds later, but I need to do that as well. But
did you tag Team YouTube?
No, I need to. I forget about doing that.
Yeah, I'll redo the whole thing and tag Team YouTube, and then you can talk about the appeal when they come back and say, well, you can appeal it in YouTube Studios. You're like, yeah, I did. And look at that, 20 seconds later. How much cost? Anyway, it's frustrating. But
oh yes, they also later said it was that there was swearing in the thumbnail or the first 6 seconds, and I'm like, literally, there is none. The first 6 seconds is, hi, welcome. My name is Ian Runkle. Welcome to Runkle the Bailey. Like, yeah, I don't know. Their process is really bizarre and opaque.
Wow. Well, let's get on to, I guess, the news stories, which will probably be equally as frustrating. One of the bigger stories of the week is Jonathan Majors. Now, I haven't been following it, and I've gotten some feedback in the comments, and I definitely want to get better about this, especially when we cut into clips. Dave, have you been following this at all?
I've been following it a little bit. I've been reading some of the text. The problem is nothing is televised or videoed as far as I can find. So I'm just getting clips from people inside the courtroom. I'm also getting copies of the text messages that were admitted.
Perfect. But what I want to do is, can somebody tell me about the case? What's going on? Because we have a tendency to go right into inside baseball, and I think we need to step back and say, this is the Jonathan Majors case. This is what he's accused of. This is what happened. Then we can get into the details. Does that make sense?
Yep. I don't know the date. That's what I wanted to pull up. But essentially, Jonathan Majors is being charged with domestic assault and against his, I guess now ex-girlfriend. And the allegations when they first came out were essentially everyone was sort of shouting Johnny Depp. Like this is being taken out of context, and she's sort of exploiting this and exaggerating a bit. And during the trial, apparently, some text messages were admitted, which didn't put a good light on Jonathan, sort of a narcissism kind of approach. But more importantly, were the photographs of his girlfriend at the time with bruised fingers. And they weren't like Amber Turd bruised, where they were kind of makeup. You could actually see they were swollen. And she had a cut behind her ear. The allegation is like he grabbed her ear or something and it sort of tore. But the problem I have with this case is it's not televised. Is this still something that could have been made up where her girlfriend sort of beat her up and that sort of thing? But apparently the jury didn't think so and found him guilty on, I want to say 3 out of the 5. There were a couple that were dismissed, charges against him. But if you guys don't know Jonathan Majors, he's been in several movies, and he was sort of an up and coming star, and he had a sort of a major get with being the lead bad guy in Marvels for this series of Marvels. He was Kang the Conqueror. And the most disappointing thing for me is that they're pulling him from Marvels, but probably rightfully so. It seems like everyone initially thought that this was like a Johnny Depp sort of situation where there's a lot of made up stuff and taking advantage of a celebrity. And it turns out that there might have been a little bit more to it, at least according to the information I'm getting from court. So that's where we are now. The next step is then, of course, he hasn't been sentenced yet. And the question is, he's going to do jail time. And I think because of his celebrity, he might get jail time just because of that. Where if it was anybody else, he probably wouldn't be. He'd probably be forced into several years of probation, along with whatever sort of counseling or therapy they find appropriate. A lot of times in these domestic violence things, they use therapy and counseling and sort of classes that they have to take and things like that. But I don't see that necessarily being the only recourse here for him because of his celebrity. A lot of fines and probably some jail time, not prison time though. But that's what's going on with Jonathan Majors for sure. And I just it just seems like maybe it was a little more credible. It wasn't so much the manipulation of the system that we were originally anticipating, sort of an Amber Turd kind of style.
Interesting. Now, Ian, thoughts on this? I see, you have this whole cancel culture thing and people are getting yanked off of things. It's hard for me to personally argue with them removing him from Marvel after a conviction, though. I feel like they jump the gun normally, but when somebody's actually convicted, then I kind of have to go, well, especially if he's going to serve time in prison, he's not necessarily going to be available to do the filming, things like that. What are your thoughts?
I mean, the thing we ask for is that people hold judgment until trial, right? Innocent until proven guilty beyond a reasonable doubt. Well, at this point, proven guilty beyond a reasonable doubt. I'm sure that Marvel told him ahead of time, like, listen, if you're convicted on this, you're done. Like, that's the end. You're out, because it was so fast, right? It was just instant. It was like same day, basically. But I mean, well, I think that it's. I don't think that that's unreasonable when somebody's been convicted, and that's really the best you can hope for. Nobody's entitled to a $1 million movie career or for anyone to like them.
See, and that's the thing is like when there was a actress on The Mandalorian that tweeted
Gina
something.
Carano.
Yes, tweeted something about Trump. I can't remember exactly what she said.
It wasn't even about Trump. She was talking about the tone going on could lead to an environment like was seen in World War II. Something along that line.
And no trial, nothing illegal, and they yanked her. That sort of puts a bad taste in everybody's mouth. And then when you see things like Jonathan Majors just getting accused and all of a sudden they start pulling people, I don't like that. But now that he's been convicted, by the way, reckless assault that wasn't intentional. The jury essentially concluded that it was accidental, and third degree and harassment. So with those, and I think the harassment really comes from the text messages, trying to convince her to lie to the hospital staff about what happened and things like that. So now, I think Disney's justified in making that decision.
I'm going to throw one at Steve now because I'm sure he'll really appreciate it. So that's an easier one. He's convicted. He's taken off. Gina Carano wasn't taken off. So let's take a hard case. Kevin Spacey. Kevin Spacey was completely canceled, was removed from House of Cards. They literally had finished an entire movie. They yanked out every single part that he did in the movie, replaced him with Donald Sutherland, I believe, for the whole movie. Well, Kevin Spacey has won every case that has been against him. What do we think about that? So, it's easy talking about some, but it's Kevin Spacey. A lot of people are creeped out by him. They have bad views of him. But technically, if we're applying the same standard, Kevin Spacey won everything.
Mm-hmm.
So I mean, I guess kind of like what Ian said, these companies have the right to make their judgment, and in theory, at least in public, innocent until proven guilty, for purposes of assuming this or deciding this person committed a crime. On the other hand, you're running a business, right? And if your belief is someone is hurting your brand and isn't going to be a good return on investment, then why would you have to keep them on? They're not even employees. I'm sure there's some kind of independent contractor thing or something like that. So, I don't like it when people are canceled out, say, for viewpoints and just talking about things. But on the other hand, if you believe in private enterprise, then companies have the right to do that. And certainly if there's, on the civil side, all across the nation, companies have to make decisions about who they have as employees and who they don't based on behavior. That you don't always wait until some criminal verdict is rendered to make your personnel decisions. But I think if you have a substantial allegation like that comes out of the blue, say like Majors, it was a good thing for them to wait and see, well, let's see how the evidence plays out on this. And once he's found guilty beyond a reasonable doubt, how can you say that, well, we still have to have him in movies and stuff? That would seem unreasonable to me.
Well, Nate, I'm going to throw it on you, of course, because you're black, so we're just going to say it. If Jonathan Majors was white, would they have waited?
I don't think so. Because usually nowadays, I'm not who else have they waited for the criminal conviction before they fire the person? Johnny Depp. Like, we could just name them all off the list, right? Most of the time, you're the allegation. That means you're gone. But I also, but I do want to say, well, two things. Number one, a lot of people miss this, but the verdict is actually inconsistent. So I think he has a pretty strong appeal on the inconsistency of the verdict. I'll touch on that, being a New York attorney. That one piece I think is going to be critical. And the second piece is that I think the double standard, this really puts out the double standard, because in a civil context, Amber Heard was found to have been lying about allegations. And now she's in Aquaman, right? She's out there in the movie. So it doesn't seem like a trial that when it's determined that you're lying about allegations, or the allegations or they've been proven beyond a reasonable doubt, means anything. It really depends on, it seems like gender, right? A white woman who can be found by a jury to be lying and have to pay somebody $10 million, that's okay. We're going to keep her in the movies. But then a guy who's found guilty of essentially a misdemeanor reckless assault, not even the DV version of it, is got to be, his career's got to be over. So there's a glaring double standard here.
And there's a double standard, and I'm not saying that the companies don't have the right to do it. I'm just saying I don't like it. Like, they have the right to choose who they're going to work with. That's not a problem. And they can even choose not to work with somebody just because of a faint whisper of an allegation. It's just,
or for no reason at all,
reason at all, right? Yeah. So that's but I'm curious, Nate, what you think about the convictions, because I have reckless assault and harassment, and you said those are inconsistent.
Yeah. So this, when I was at the DA's office, this is what we used to do a lot. So we not only charge with the crime, but particularly all the underlying crimes, or in this time, one is the violation, but also the underlying violations if they amount to crime. So, for instance, if I'm charging you with a bank robbery or robbery, I'd also charge you with the theft, right? So you'll have the robbery charge, but then I'll also charge you with the theft, and then I'll also charge you with the underlying assault. So just in case they find that you didn't commit the robbery, they may say what you did to commit the assault, brandishing a weapon. And then I'll charge you with a weapons charge, right? Because for armed robbery, you have to have a weapons charge in there, you have an assault, and then you have a theft. So I'll charge you with each one of the three underlying charges individually and the robbery. So for those of you who are not lawyers, there's a doctrine generally called the merger doctrine. And the merger doctrine says if I find you guilty of the armed robbery, then those other minor charges don't matter because they all are merged into the top count. So it's the merger doctrine. Now, some states deal with this, some states don't, but I don't want to get too deep into that. So in New York, the problem with Jonathan Majors' conviction is that first you had the intentional assault. He was found not guilty of that. That's fine. But what the DA's office did was charge him with aggravated harassment. Now, aggravated harassment has two underlying crimes that you have to be guilty of, or two underlying causes of action. You have to be guilty of harassment, of the violation of harassment, which is to annoy, whatever. So for everybody who doesn't understand, in New York, harassment is, let's say if I'm slapping you and I'm just slapping you and I don't cause any physical injury, well, that's called the violation of harassment. It's not a criminal charge, it's essentially a parking ticket, but that's what harassment is. If I punch you and you are not injured at all, but as soon as an injury occurs, then it becomes aggravated harassment. So the difference between aggravated harassment and regular harassment is whether my actions or my physical contact caused you an injury. So for aggravated harassment, you have to have the underlying harassment, and then you have to have the injury. So they charged him with harassment, which is, him hitting her but not causing an injury. Then they also charged him with assault. Now, for aggravated harassment, you have to have those two things have to be true. You have to have the harassment element, and then you have to have an assault, essentially causing injury. But it doesn't matter how you cause it. It can be reckless, it can be negligent, but you've caused an injury. So in this particular case, the event was what happened in the vehicle. I'm sorry, am I losing anybody here? Because I know
no, I'm fine.
No. Yeah.
All right. So at the Jonathan Majors, the event was in the car. So the jury said, okay, in the car, we're going to find him guilty of harassment. Check. And then they said, well, that harassment, we're also going to find him guilty of causing her physical injury, which is beyond a reasonable doubt, which is the assault, the reckless assault. Check. So if they're saying both of those are true as a matter of law, then when they were asked the question, well, is he also guilty of aggravated harassment, which is the same thing, the harassment and an assault? They said, no, he's not guilty beyond a reasonable doubt. Matter of fact, they acquitted him on that charge. So the inconsistency here is, well, if that's true, he can't be not guilty of the aggravated harassment, which is the harassment and assault, and then guilty of the underlying elements of it, the harassment and the assault in separate charges. So the only way this works is if they're saying that the assault or the underlying harassment occurred at some other time. But even the jury and even the prosecutor's office say it all occurred in the car. So essentially they're saying he's guilty of he's not guilty of harassing her and causing her physical injury. But then when we separate the charges, he's guilty of harassing her and then causing her physical injury. So he's not guilty, but you're guilty of the same thing.
So the New York harassment charge that he was charged with was different than what would be charged as far as harassment in Michigan, which apparently, so in New York, it has to contain that physical portion.
Well, aggravated. So harassment in New York is if I'm making physical contact with someone and not causing a physical injury. So for instance, if I slap you, that's harassment. But now if there's a bruise that occurs, that's aggravated harassment. The physical injury is what makes it aggravated harassment. So they charged him with harassment and aggravated harassment. But the difference between harassment and aggravated is really the assault. If you have an harassment that includes an assault, it's aggravated harassment. It's textbook aggravated harassment.
Okay.
So the reason why the verdict is inconsistent is because they essentially found him guilty and not guilty of the same thing. Matter of fact, because I'm doing a video and I got a chart. I know this is legal nerdy stuff. So
Nate, how often do they actually overturn on inconsistent verdict?
Yeah, that's what I was going to ask.
But it all depends. It honestly all depends on the judge. Here they're gonna really be looking for a reason why the jury couldn't have found them separately. So let me go through the chart because I think this visual may help. So he was found. What he's found essentially, these are the 4 charges. So harassment, the first one, harassment, is actually to annoy. Aggravated harassment is to annoy plus injury. Assault is injury recklessly, and then you have injury, assault intended. So what's in red is what he was found not guilty of. What's in blue he's found guilty of.
Oh wow!
But if we look
so he intended to annoy her and he accidentally injured her.
Yes, but now if you look at it, harassment to annoy plus an injury, which is reckless, that is annoy plus injury. That is aggravated harassment. So the jury found him not guilty of it, but then they also found him guilty of it. So this is just inconsistent. It doesn't make any sense.
Now, these text messages that they admitted in court, did they were sent, I'm assuming, not in the vehicle because they're obviously communicating after the fact. It looks like. But that couldn't be harassment. That couldn't be the harassment if the state's alleging that the harassment took place in the vehicle.
Exactly. So these 4 charges are from. So these are the 4 charges. These 4 charges are for everything that took place in the vehicle. So, but if that's true, then he can't. Then essentially, they're finding him guilty of each one of the underlying elements, but not guilty. If you put them together, they're saying it's not guilty. It's a weird little quandary here. But I'm assuming what the prosecutors are going to argue is that the harassment occurred later or the assault occurred later. It didn't occur in a car. That's the only way this would work, because now you definitely would have an inconsistent verdict. He's not guilty beyond a reasonable doubt for the crimes if you put them together, but he's guilty of them when you separate them.
Nate, let me ask you this question: how likely is the judge to suspend the sentence while this is considered on appeal, or is he going to have to go in and behind bars while this gets considered? That makes a big difference in his life, of course.
Does he work for Trump?
Well, two things. Number one, he's going to face any jail time. If anybody's telling you that, they're being ridiculous. You have somebody who has absolutely no criminal history, no criminal record.
I thought because of his celebrity, he might get some as a deterrent.
No.
If the injury was reckless too, that seems really problematic to jail somebody when the jury found him to be reckless, not malicious.
Yeah, it's again in New York. There's no but for misdemeanor reckless assault, no one's serving any jail time. Generally, in 99.99% of the cases, because I've handled a lot of assault cases, what they do is that you've assaulted someone. If it's your first time, they give you what's called a conditional discharge. That means if you are a good boy or girl for the 6 months, then what we'll do is we'll remove it and make it a violation so you won't have a criminal record. They offer that to every single person. I think it's actually even written in the law. So if this is his first time ever being charged with this, he's charged with a violation, which won't even matter because the violation is a parking ticket, the harassment, and the assault is the only thing. So in 6 months, he'll essentially have a flawless record again.
Nate, question though, you said that the prosecutor is going to be trapped in having to say the assault was in a different location or something is a different location. Yeah. Can you do that after the fact if you state during the trial that it's all in one location? I mean, how can you change the story after you presented the whole trial?
Well, the jury, you have to make it so that you have to make the argument that the jury can find some possible way the jury can find that these are consistent. Yeah. So is there any theoretically conceivable way? And if the prosecution's arguing we're only, the events that we're charging the crimes for are stuff that happened in the vehicle. The assaults and the injuries happened in the vehicle. If that's the case, then the only other argument they can make is that the harassment that they found him guilty of had to happen some other time. Maybe it was the phone calls. Maybe it was when he was at the house. But it could not have happened in that car.
But he wasn't charged. Help me understand. Again, I'm a dumb civilian. If they didn't explicitly say it during the trial, I mean, I'm a jury member and I'll just make something up. Be like, you know what? I'm going to convict him because he's not guilty here, but he's probably guilty of something. I mean, that's the same logic in my head.
They're going to have to go through the record and say, okay, well, was that even argued? If the sole argument was it happened in the car, then these verdicts are inconsistent because he can't be guilty and not guilty of essentially the same thing, all in the same setting.
And should it even go to appeal, or should the judge step in if the judge is actually looking on, just overturn it or modify it?
I was going to say,
go ahead.
The judge is going to be worried about wanting to overturn a jury verdict because even if it may seem inconsistent, at least I know I've read other, not only in my state, Ohio, but I've read other cases where, courts have said, that's, the jury came to the conclusion it came to. It's not a violation of law. It may seem inconsistent, but a lot of times they'll still get held up because that's the decision the jury came to. And it might, it may be inconsistent, but it's not necessarily a manifest injustice to have it be inconsistent.
Well, that's like a reverse nullification, right?
Well, no, because if it's truly an issue where there was no way a jury could have found it, that's a separate thing. But in this case here, where I think this may have been an issue of jury instructions, it sounds like the jury may have been confused about how to actually charge this or convict him. But I'm thinking that if you ask those jurors, did he strike this woman? They're going to say yes. I just think
I was going to say it might be the best not to appeal, because if you get it set aside and you get better instructions to the jury, they might actually find them guilty of worse charges.
Yeah,
but I don't
the inconsistency is we shouldn't have acquitted you on some of that.
But the issue, see, the thing is that it wouldn't actually go back because of the not guilties, right? Yeah. So as soon as they find him not guilties, it's the guilty verdicts that are at issue here. It's one even been not guilty. You found him not guilty, he's done. So the argument that if I'm Jonathan Major's lawyer, my argument is he was actually found not guilty of these same two underlying offenses in that same setting. So he can't be guilty of them. And now, if you want to go back and say we're going to redo it, you can't redo it because they literally found him not guilty of the aggravated assault, which is the harassment and the assault combined.
Yeah, and the funny thing is with that, apparently in Georgia you could until recently. So the Supreme Court just heard about that case.
So, we talked about that. That was I think more of that was kind of what I was getting at with the distinction is that I think the issue here with Jonathan Majors is a factual distinction, whereas that Georgia case was more of a legal distinction. You can't be guilty of of committing the same act and then not guilty because you're insane at the time of the act. I think that was more of a legal distinction Georgia was dealing with.
Well, even if we just dumb this down, can you be guilty and not guilty? Can the jury find you guilty of the robbery and not guilty of the robbery in the same setting at the same time?
I would like to say no. They can't do that. Like,
and then which one? And then which one trumps which? Which trumps which? Is it the guilty verdict that trumps the guilty verdict, or the guilty that? And in every case that you've seen, it's always a not guilty verdict trumps any guilty verdict. If you
Nate has to bring Trump into everything.
Yes. I didn't say Trump. Oh, Trump's, yeah, Trump.
You said it 4 times. No, I just had to.
Living rent free. Living rent free.
Algorithm.
Rent free. That's right.
Man. Speaking of that, though, I do want to shift because while we're talking about juries and decisions, Steve, Southern Law, you had discussed the idea of how juries are just sort of making up these judgments that seem to be a little excessive. Like I think that we have a new measurement out there that I call an Alex Jones. Like, Rudy Giuliani was convicted with a 0.5 Alex Jones judgment. Can you break down what's going on and what you see happening?
Well, so there's lots of issues in these kind of cases, and one of them is the concept of the default judgment, the judge striking the answer, which has happened in several cases, and therefore the defendant admits fault and liability, and so the trial is really just about how much money you get. And I'm not talking about that, although there are a lot of good reasons to talk about it. I'm talking about the idea of compensatory damages. So something happened to you, an injury, and you get a judgment that makes you whole for that. So let's say I'm driving down the road and Mother Teresa rear ends my car and causes $500 of damage to the bumper. What am I due? $500. Now let's say a Nazi hits the back of my car and causes $500 of bumper damage. What do I get? $500. So whether you
that's a hate crime.
Yeah, whether you hate the defendant or not is not supposed to change your compensatory damages. It might have an impact on punitive. But if you're a good plaintiff's lawyer, you do want to paint the defendant more like a Nazi rather than, say, Mother Teresa, right? And so I guess my issue with this is, at some degree, the Alex Jones case, of course, but this Giuliani thing is, whether you like the guy or you hate the guy or whatever, do you really believe these people suffered $75 million, roughly, of compensatory economic and non-economic loss damages? Not punitive, but that they actually experienced that loss in their life worth that level of money, or was that sum of money really directed to punish Giuliani? And same thing maybe with the Jones case, and we'll see on some of these other ones. And I think that's true to some degree, say in the Maya Kowalski case, where you could see the hospital being liable and hate them and not like their witnesses. But for some particular instances, like the alleged battery where she was hugged and stuff, which is all improper, potentially, agree with all that. But I think they gave, $19 million compensatory damages, not punitive.
Can you explain the difference between compensatory and punitive? Because I think that's the
relevant
relevant part.
He just did.
Yeah, just to get you back to where you were before that happened. So
no, I meant a little more detail, Joe. Yeah. Sorry to jump in, but like you're talking about wages that they've lost, right. Reputation, or a little more detail.
Yeah. So in a case like where it's not a car bumper, like what you're saying is an injury to the person theoretically. Mm-hmm. So in Maya's case, there's millions of dollars for potential future therapy for being hugged and kissed or whatever. And also for, just the trauma of having it happen, for the loss of life experience, maybe lost wages. Those are hypothetically all solid compensatory damages. My issue with that is, does that amount make sense? Because I feel like it's polluted because of what the hospital did regarding the ultimate result with the mother, right? Which is, I don't like the hospital in this case either. But my point is, sometimes I see in these cases, it sure looks like the plaintiff's attorneys have been successful, say in a Giuliani case, with the help of the judge, of course, in convincing a jury to give a compensatory award that looks a lot like punitive damages and not any theoretical, let's just get you back to the starting line for the damage that was caused. Again, that's punitive damages can help you punish the person. That's my feeling on these cases. These are ridiculous verdicts, and judges ought to be reducing them, but I don't think that,
Steve, isn't that the case because most of the legislatures have limited punitive damages? Like, for instance, in the Depp case, Depp's they found 5 million in punitive, but the state said, well, you can only get 350,000 in punitive. So it's a way for the jury to kind of circumvent the legislature by saying, okay, well, we think it's $1 billion in punitive damages.
If the jury knows.
Right, which they, in theory, they're not supposed to. And now it is a way, Nate, in which I agree with you. For example, the plaintiff's lawyers know these limits are coming. So they've got to fuel up the compensatory side as much as they can, because often the punitive damages are either capped by some or capped at a multiple of compensatory, or you have to find some egregious conduct to come out from underneath the cap. And they've been great at it. I mean, you look at, say, again, the Maya case, you might think that all of that money is deserved in the total picture of things. I'm not arguing that. My point is, for the specific counts that the jury awarded damages within, it sure looked like they were trying to get to a result rather than measuring damages. But yeah, I mean, the people were like, oh, we don't like runaway verdicts and stuff like that. But are these those?
What kind of charges can somebody declare bankruptcy against? If I recall, one of them you can never escape. It's hanging over your head. Which one is that?
Well, this is generally it's an intentional tort. So defamation and things like that would be an intentional tort that you can't discharge. But he has filed a Chapter 11, which is reorganization, not discharge of debt. So I think he's safe there, even though it's an intentional tort.
But it stays everything regardless in the meantime.
Yeah.
Yeah.
The other thing,
it's
sorry, go ahead.
Like that's the thing. You know, people think the most powerful judge in America, the most powerful person in America is a bankruptcy judge and a bankruptcy trustee. I mean, you can stop everything. All it takes, you've got an eviction, you're getting foreclosed. I'm in bankruptcy, stops. Every single thing bankruptcy can pretty much stop. That's how powerful it is.
Every proceeding.
Engaging in judgment execution, it is annoying AF. Because
it's
the filing itself. That's what people don't realize. You literally just go to court and file papers. Now, bankruptcy courts are not stupid about how that could be abused. So a lot of times what someone will do if they're facing judgment execution, like a Giuliani situation over here, they may go to bankruptcy court, file for bankruptcy, and they can file under Chapter 11, Chapter 7, and get that stay in order to just stop the immediate pressure of judgment execution, and then know that once you file the papers, there's a series of steps that the applicant for bankruptcy has to follow in relatively short order over the next several weeks, that in order to progress the bankruptcy along, including listing off their assets and going forward with it. Many people who are just looking for that relief don't want to have to go through that sort of exposure. So they'll file for it and maybe move many of their assets around over the next couple of weeks, and then have the bankruptcy dismissed. Dismissed means that the application is denied, it's rejected. Then if they want to come back and file for bankruptcy a second time, and especially if they do it more than twice, bankruptcy courts are loath to give them very long, if any, relief. And it's something that creditors will frequently bring up to bankruptcy court, that, hey, this is the third time in the last 2 years that they brought forward with it, that they've had bankruptcy cases dismissed. And bankruptcy courts will frequently, in that circumstance, knock it off within like a day or two, rather than having to wait several weeks. At least that's the experience that I've seen. But
and also, if you fail to list all of your debts or assets on your schedules when you initially file, the judges don't like that either, because they see, again, like what you're saying, Joe, you're just filing it to stop everything, and you're trying to perpetrate some sort of fraud on the court, and they will kick it very quickly too. So you got to do it the right way. It shouldn't be abused because of the power.
One thing though, I think what Giuliani did was exactly what you do. You get a judgment for some crazy $100 million. You file for the bankruptcy, and now, because it's compensatory damages, they're only going to get pennies for $1. They'll go, boom, boom, but this is all he's got. He obviously doesn't have 160 million. It'll be, you go to do the creditor stuff, and he pays pennies on $1, and then after a short amount of time, he's back to it like it didn't even happen. So I think he kind of had no choice. He may appeal or whatever, but I think this was the smartest thing he could do after getting 100, because this judgment obviously
he had to
more than
there was nothing. There was nothing. He had no choice. He had to file bankruptcy. That was clear. And to follow up on what Steve said like a few minutes ago about the whole compensatory thing, if you want to think about like what's fair, like as far as compensatory. You have, and he made a great analysis pointing out that it doesn't matter whether your bumper is hit by some random person on the street or by Goebbels. It's the same compensatory. That doesn't change. So you have to ask yourself, if Ruby Freeman had literally been killed by someone basically had come up and like, what do you think? And then she went to court and sued, and she was killed by John Smith from Oakland, California. No one heard of this guy ever before. Now she goes and sues. The estate comes and sues for that loss. What do you think that she would get? The family would get $5 million, $10 million. There's zero chance they would get $100 million. So how can you say that what Giuliani did to her was worse than that? It doesn't make sense as far as compensatory. Now you want to say punitive, that because he was benefiting from it and he was doing all this other stuff, so you want to punish him on top on a punitive sense. Okay, that there's logic to figure out what's appropriate for punitive to make sure that people don't do this sort of thing in the future, assuming you believe that he was wrong, the court believes he was wrong. But as far as compensatory, when a jury plays around with such ridiculously gross high numbers that they would never give a family of a victim of murder, it strikes of just fat corrupt judicial work. And that's very disheartening.
Don't hate me and chat. Don't say it's Nate being he loves him. No, I don't. I think this is a bad verdict, but I'm going to say it. This is their argument, not my argument. This is their argument for the story damages. So I don't want to see the chat saying Nate's argument. It's not. It's their argument. Their argument was that this particular thing is for, in a defamation context, is the harm is not the punitive harm, but the reputational harm that they suffered nationwide, because you have half the country who still believes that they did this. So this is a loss of opportunity. This is a loss of.
I still want to know what they were doing in that room after everybody left.
Exactly, and their attorneys point to exactly what you're saying and saying, even no matter how much we've said that this is BS, they could never recover, and this amount is so they can, because it's going to be hard for them to get jobs. It's going to be hard for that type of thing. Now, I disagree with that argument. I think Joe's right. If they were killed, they wouldn't get. I would say double what they were if they got killed. But right now, they're saying that $100 million is because half the country believes that they are fraudsters and all this other stuff, and they can't live in the real world and get opportunities as everyone else because of this. And that money is to make them whole in that way.
Isn't that like an
argument? But that's their argument.
Isn't that an actuarial question? I'm curious, because I would really like to know, especially when claims are made like that. Mm-hmm. Oh, so you're not working now? Yeah, you don't have any income?
Well,
you lost it all? No. But isn't that relevant? If you're saying compensatory, you should say, okay, that $500 car wreck, going all the way back to Steve, I couldn't work for a week because I had to go to the chiropractor. Well, right. That's a legitimate statement. So let's ask that question. Is this a speculative thing? You're going to suddenly be worth millions and millions of dollars? Really?
Well, that's the thing. Like, so what was their job? What was their average, net, even let's go gross wages for the year? How old were they? How long were they expected to work? What were their education levels? And that's their compensatory damages.
There's up to five categories that fall under compensatory. Up to 5, and those 5 really are physical damages, right? So if you think about like any sort of injury, I'm sorry, David, I shouldn't cut you off. That was rude.
No, you're fine. What I was saying is like, okay, let's assume that they can't work because of this defamation stuff. Okay, well then, how many years were you likely to work going forward, and what were you likely to earn? And that's it. It's not 150 million or whatever the stupid number is.
Yeah. I think.
And that loss of wages is one of the 5 categories. There's up to 5 categories, and this is that anyone who's actually thought philosophically about what type of damages someone can sustain by a result of a wrongful tort, a wrongful harming of another person. There's up to 5. There's damage to your physical property is one of them. There's their medical damages, and that medical could be like physical, like surgeon, or it could be psychological and getting treatment of that sort of basis. Mm-hmm. There's lost time from work, and and whatever damages those are. So you figure out, okay, whether that lost time of work or lost opportunity, as Nate just brought up, is that the rest of their lives they can't get a job. Okay, so what were they earning? What is their potential future earnings? And you come up with a number for that. Then you come up and
I
then
mean,
the other two categories. The other, so I'll just go in a second.
Go ahead.
The other two categories that some people bring up is the element of humiliation, as to like what do you assess for the humiliation, and that will vary from one district to another, and literally from one location, one jurisdiction to another, as to whether or not you can add anything for that or not. And the last one, which is what personal injury attorneys go for all the time, is pain and suffering. That's where the big bucks come in, is pain and suffering, which a lot of people will include embarrassment into the whole pain and suffering. So that's why whether it's distinct or not sometimes doesn't even matter.
Mental anguish. Yes.
Right. So pain and suffering, the way that most people say is you basically have to say, like, okay, if I told you that I'm going to cut off this part of your body and I want your consent for that, and there'll be this level of pain, how much money would you demand? Then say, you know what, I'll sell you that I'll give you to let you do that. That's how you figure out. That's how you're supposed to try to figure out how much pain and suffering is. You take all those categories and add them into a number, and that's your compensation.
Well, Joe, I think you.
Well,
there's
Ian was
one more thing that you have to just. Oh, I'm sorry. Go ahead, Ian. Oh, go ahead. Sorry.
I mean, Nate earlier made the point saying like maybe juries are using this as a way to get around caps. I think it's actually simpler than that. I think it's that juries don't understand any of this. They don't understand where the caps are. And they just lump all of this together into a big pile of how much is FU money.
Yeah, how much do we
and yeah, and I don't think they actually get any of these discussions when we start talking about damages, because it gets, so I don't know that they're sitting there going, how much would it cost to take off my leg or whatever else. They're just going, how much do I dislike this guy? And I think that what we've seen, like when you look at the Maya trial, the jury seemed like surprised when they were brought back to do the second phase of damages, to be like, now how much is punitive? And they're like, didn't we already do that? Was kind of the feeling that sort of I got watching that. And I'm like, I think that's where juries are a lot of the time, is they just kind of have that pool of screw you. So.
Well, and that's what I argue. But that's the job of the plaintiff's counsel, right? So I had a client that had his middle and ring fingers were all kind of messed up on his right hand, his dominant hand. And once we got past all of the liability stuff, we argued damages, and I came up with an absurdly low number that I thought the jury could easily double in their minds. And it was essentially, I said, listen, this guy is such and such age. How much would it be worth for you not to be able to functionally use your dominant hand for the rest of your life? $25 a day. Does that seem fair enough? And it came out to, an astronomical number, in the six figures. But I thought that was a simple way to get it to the jury. Is it worth $25 a day or more for you not to be able to use your dominant hand? And they jumped all over that. It was nice and easy.
Yeah, that's smart.
It's just the way you frame it.
That's smart lawyering.
Yeah, that's great lawyering. Well, but I want to just add something to Joe's stuff.
Cups of coffee a day. No.
Yeah, exactly.
Just to add on to what Joe said is that everything Joe said is correct. I would just also add the looking back part and looking forward part, because in some of those criteria, you're looking back what the person made, blah, 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 blah. And then some you're looking forward. What's the potential of what they can make, and so forth and so forth. And I think this jury was saying the pain and suffering is all but so much. But I think most of this money is from looking forward, not looking back, because it only makes sense if they're giving them stuff looking forward. Because again, somebody making phone calls to you saying that you're an idiot or whatever, that's not worth $100 million. So they formulated in some way where they're saying we're paying them for future stuff, and that's the only way legally I think this even makes sense.
And why is humiliation not part of pain and suffering, by the way?
So listen, so part of those verdicts, I sent Eric a picture of that, is for the intentional infliction of emotional distress claim. So that's not lost earnings, right? That's the anguish and all this stuff. And I think that's 20 million, 40 million or something out of that. So They definitely assigned a giant sum of money for the horror of knowing or thinking that Rudy Giuliani lied about you and people believe him. that horror that you'll have to live with for the rest of your life is worth something like $40 million. I mean, now
That's worse than what the chat says about me.
I want him to lie about
Nate,
me,
you
please.
need 40 million, baby. You need 40 million. We
right.
just need a solvent chatter.
You just sue your chat. That'll work.
Yeah, we just need a
That's what
solvent
you guys
chatter.
expect lawsuit.
Wow. Okay, while we're on compensation, I want to bring this story up. This is just one of my personal favorites, and it's about the Son of Sam laws. I don't know if you guys are familiar with them. They are the laws that prevent a killer or criminal from selling their life story or profiting off of their crimes. So let's say, Jeffrey Dahmer had wanted to write a book, or, in this case, Son of Sam, David Berkowitz said, I'm going to sell my life story to fill in the blank, and they're going to make a movie on it. That's illegal. However, something just went down with the Gigolo killer Huerman. His wife apparently sold her life story for 7 figures to the Peacock Network, and now people are wanting to adjust the Son of Sam laws to not only include the actual felon themselves or accused or whatever the hell it is, but also their family members, which I will just flat out say strikes me as completely
Unconstitutional.
Yeah.
ridiculous, horrible, and
Yeah, it's not her fault her husband was murdering.
Yeah. What
unless she
crime
did-
did she break?
if she did help him in some way or whatever, then fair enough. But
And people who want to do this, do they realize the original Son of Sam law was found unconstitutional?
Yeah.
Yeah.
I mean, the Son of Sam laws now are different than when they originally conceived because they can't target speech, right?
Yeah.
So they have to make these more broad against the criminals in order to capture the speech, right? So there's no way you can do this to their family. I mean, come on.
Well, even I think a lot of people don't know. It's like we went to some of Sam laws. It's the proceeds of, like, they can still sell their story, but all those proceeds goes to the victims. It doesn't go to the killer. So that's the nuance here.
Let me frame an issue. All right. So we have somebody who's in a committed, loving relationship. They've been married for 20 years. They have kids together. Secretly, the husband has a life that nobody knows about and is out there unaliving people day in and day out. And he gets arrested and charged. Now, all of a sudden, this wife and mother who's raising 12 children on her own has absolutely no source of income because the defendant is the one that's unalived. You're telling me that you don't want her to be able to sell her story to make a few bucks so that she could take care of her family? Now, isn't she also a victim? Isn't she also a victim though in that scenario?
of course she is.
Yeah.
Of course
Right?
she is.
So are we
And
going to ban victims from making money on their stories?
I think it's the amount. I think if it was $100,000, people would be like, "Oh, okay." But it's
Well,
like, "Oh, wait a minute, she's making millions." Who cares?
Let's
I don't think
arbitrarily
there's no
put
ban.
as many zeros behind a number as we want to make it sound interesting. But the problem is you're still penalizing, in my opinion, a victim
agree.
here.
And
I
you're
agree.
just trying to suppress speech. Like, let's be honest. They'd be ticked off even if she was just selling her story for $12.
Yeah.
I mean, the zeros add some spice to it, but people are just upset that, a lot of the time they're upset that these stories are getting told at all. And I mean, I don't
like
see
this
how
at all.
this is reasonable at all.
Well, some of these laws that are Son of Sam, now they're written if they want to survive in a way that captures more income than just a particular speech by the inmate, because that's why the original one was held unconstitutional. But they can also capture if the inmate is trying to create a dodge for this. So if somebody really thought, well, she's getting the money, but actually he's getting the money because, there's ways to potentially challenge that. But generally speaking, she should be able to do whatever she wants to do, like anybody else can do what they want to do. I mean, what if it was his cousin? Does it have to be his wife, or his ex-wife or his father-in-law? I mean, it's anybody, whoever, his best friend or a
his
friend.
third cousin.
Yeah. Where's the family line drawn
and
as
here-
well?
Well, the really fun aspect is that often family members aren't going to be a victim just in the sense that was described before of like loss of income, but like actually victimized in the sense of like maybe they survived an attack. Because this could end up capturing a whole bunch of like if you're saying that family members can't do it, what happens if your spouse attempts to murder you and then you write a story about it? Like, is that going to be captured because it's your spouse or your sibling? Like, this is ridiculous.
Yeah. I will say Dr. D in chat, not the name necessarily, but he does bring up a good idea. Why don't two inmates write each other's stories?
Yeah, I saw that.
But I mean, the name is also awesome, though.
That's yes, but that right there is that's thinking like a lawyer. Well,
That's clever.
You go in and argue. Hey, they're not.
Yeah.
He's not. Jeffrey Dahmer's not writing. John Wayne Gacy's story. He's writing.
I was Dahmer's cellmate.
Yeah.
No, question on that, Steve. When you were talking about the constitutionality, now the family, I think all of us agree, is just ludicrous. That now let's go back to the accused or the convicted or the felon or whatever. Is it possible that I'm just going to throw out defamation, just thinking of a category, but if they're writing a story about a crime they committed, could it be seen as further victimizing the victim through the story? Would that be one way to stop it? And I don't know if that would be like a defamation type of thing. I'm asking all the lawyers. So
well, I don't think you could just per se stop somebody from talking. But the other thing is there are Son of Sam laws that should be legal. But what I'm saying is they've been written so that they capture more than just speech. That way, if the law is analyzed, it's not targeting that this person gives one perspective on a crime, they can't do it. That was the issue with the original Son of Sam law. It's kind of like if let's say the convicted person makes money in any way. What if they won the lottery? What if somebody gives Daryl Brooks a lottery ticket and he wins $50 million? That can be captured for the benefit of victims. Also, if he sells his story. So by making it more than just speech, they can have these laws be, they can have them be legal. But I'm not in favor of just restricting people's speech just because we don't like the people. But on the other hand, I'm not in favor of criminals having a bunch of money because they kill people. So I like kind of the way they've recalibrated the laws. But capturing people's families and that, or you wrote a biography and maybe you mentioned something about it or something, that's all. No, I don't think so.
And again, you're assuming that is somehow benefiting the defendant, right? And it's this is an estranged wife, according to the reports. I don't know how estranged they are, but
she filed divorce the day he was arrested.
Okay,
but just to be clear, there's a lot of ifs with that, though. She's been there's a little bit more with her in this story than it was the she's no babe in the woods. I'll say that.
She may be an estranged wife, but she's also a strange wife. I think.
Yeah. But again, she, to my knowledge, is not being accused of any wrongdoing, let alone violating any law. So, why are we in a position at all to dictate what she can and cannot write about and collect the proceeds from?
I agree. I think a lot of it's envy. It's kind of like saying, you know what, they're going to pay that football player too much damn money. I think that they should cut their salary. Like, I don't see it as being that different.
We should ban NFL wives from talking about their husbands.
Agree.
The other thing about the will it cause harm? The whole point of free speech protections is to cover speech we don't like, because speech that everyone agrees with and everyone thinks is great, you don't need freedom of speech to say it. Nobody's trying to stop you. It is actually to stop or to prevent the government from stopping you when you're being a jerk or when you're saying something that other people would want you to stop talking about. So
Tuesdays with Morey offends me. Can I sue Mitch Albom?
I don't know. While we're on, somebody's saying this is a weird subject for holiday season. Have you watched this show before? I encourage you to please tune in, because you will get many, many wild subjects. But let's see, Nate, I think you might want to talk about this, but Abbott has gotten clever again. Abbott did the busing of migrants to blue areas and sanctuary cities, which I thought was brilliant, and started a trend of people going there. It's causing Eric Adams no shortage of pain at this point. But I guess Chicago is made it illegal for buses to come in, and to get around it, Abbott and crew are saying, okay, we'll fly them.
Yeah, so this is what's been going on. The people of Chicago, sanctuary city, turned it from sanctuary city to welcoming city. We want migrants. So the people in Texas and Arizona was like, okay, well, if you want migrants, we'll send them up to you. So they started busing them up there. So, it became crazy and yada, yada, yada. So now Chicago said, well, we don't want any more migrants to come, but we still want to pretend to be a sanctuary city. So how do we do it? So what they did was they've passed regulations that essentially make it illegal for buses to come in and drop off migrants. That's essentially what they're doing. Now, obviously, there's going to be some federal issues with this, which, the right to transportation and things like this, but they've done it. So in other words, a bus company from Texas needs a permit from the city of Chicago to be able to drop people off in Chicago. And they're not giving out permits. So that's essentially what they're doing. So the bus companies were like, okay, what we'll do is we won't drop them off in Chicago then. We'll drop them off in all the places right around Chicago. So they've been dropping them off at the border places around Chicago. So all the border places around Chicago essentially passed the same law. So for instance, if the bus from Texas drops off migrants in the suburbs of Chicago, that bus driver can be charged $750 per person they drop off and a $30,000 fine, and their bus be impounded. If they drop them off Chicago, you get similarly the same thing, $10,000 fine, bus impounding. So that's what Chicago started doing, impounding buses. So what buses started doing was just like, okay, we'll just drive into Chicago and drop them off anywhere. It doesn't matter. So now the city sued all 55 bus companies for millions of dollars, saying because they're violating Chicago's law. So they went back to Texas and said, hey, listen, we tried to get around this thing in Chicago, but it's not happening. Because Chicago is doing their thing. So Abbott got upset and was like, okay, since we're going to buy a whole bunch of private planes and put the migrants on private planes and fly them up because you have no jurisdiction in the airports. And now that's what Chicago's doing. Now that's made. But the issue with that is that they've now sent more people, because now you get to send more people faster through the planes. So now it's become an even worse crisis. And now you can't pass a law saying people can't come in by plane. So it's become like even a worse crisis. So now the people in Chicago are saying, what do we do? Do we how can we stop this now? Because obviously we now have run out of money, and now we can't stop these people from coming in because they're flying them here first class and private jets.
I love that. Well, they do have a very easy solution. We're not a sanctuary city.
Yeah.
Problem solved. Lock them up, boot them out. I mean, it's kind of funny. They'll do everything they can to trip over themselves to stop, but that's one easy solution. Correct your laws. Get in line.
Yeah, we should make it illegal to have a sanctuary city. That would be ideal, but you'll never get that passed.
What's interesting, just from a rational thought process, is that not everyone, there's half the people are okay with sanctuary cities, but the same half of people are not okay with states or cities that try to enforce the laws.
Well, that's called NIMBY. You're talking about the NIMBY problem.
Not my bad.
They love exactly, and that's what Abbott took advantage of, and that's why it's hilarious. Quite literally, we are a sanctuary city. Why? Because we're not Texas. We're not a border town. The only people we have to worry about are freaking Canadians. And
how many of them will make it up here? That's basically what they're saying. It's the perfect virtue signal that I can show you how virtuous I am without ever having to pay consequences of that virtue.
Yes.
So, here is the news report where now they're literally going crazy over this thing. I'll share it, but it's funny, even though it's kind of sad. It's funny because these people wanted to be sanctuary cities so bad, and now they're like, there's no way we can stop this unless the federal government stops it, and obviously the Republicans aren't going to stop this. So.
Program, while local leaders response to this not know until they are here. That is what happened last night. Texas officials say it is in response to the city obstructing its busing program, while local leaders are calling it trafficking. The direction of it. More than 100 migrants boarded a private plane from El Paso to O'Hare Tuesday. Abbott's office tells our sister station in Dallas that because Mayor Brandon Johnson is, quote, targeting migrant buses from Texas, we are expanding our operation to include flights to Chicago, unquote.
We have a governor that now openly and defiantly is saying that he's going to commit human trafficking to show Chicago and to teach us a lesson.
So now I love the wording.
Nice spin. That's a good spin, though. If you're gonna,
I spent a show talking about the term trafficking and how it's such a great buzzword for the left to claim, because technically Your trafficking means moving someone, but the context of trafficking and why when we hear trafficking correctly, our skin crawls is because we envision someone who's being trafficked for basically the purposes of being used as a toy by some nefarious individual. That's essentially, whether that toy is on manual labor or something far more gross and invasive, that's what we picture when it comes to trafficking. But this is an abuse of that term, clearly, because that's not what Abbott is looking for. That anything of that particular nature is more likely to happen in Chicago than it is in El Paso is kind of ridiculous. But that's why the Democrats are using that term, and they might be able to get away with it under the Mann Act in theory with respect to any children, because you're not allowed to trap now. But under the Mann Act, I didn't look at the Mann Act since I was covering Ghislaine Maxwell.
There's no sexual trafficking.
I think there has to be a sexual element to
Does it
right?
sexual, or is it just any illegal purposes?
Well, there's legal purposes, yeah, but it's not illegal. We want people to be safe and healthy. Yeah. What's the illegal purpose?
There's no illegal purpose here. The people saying we want to go to Chicago, and they're saying jump on this plane. We'll take
I just want to make sure the definition is right in my mind.
They're not demanding them. They're not putting them, holding them at gunpoint and saying, get on this plane and we're taking you there. Are they?
No. Actually, it's one of the biggest fallacies too is that they're saying only the Republican governors and mayors are doing this. Actually, the town that has the most illegal immigrants coming across the border is El Paso. And that mayor is a Democratic mayor, and he's actually sending more migrants up to Chicago and New York than anybody else. But the difference between him and the governor of Texas is that they're saying he coordinates, he tells us they're coming. But if he's, but that means nothing. If he tells you it's coming, it's still coming. Yeah.
Wait, transportation of adults and children by compelling them to perform labor, or the other part. Okay, so the compelling part is basically, so if they're going voluntarily to go pick strawberries in Western Michigan, which they do every year, it's not compelling them. Where they're doing it voluntarily, so it's not an issue. So if they're getting on the plane voluntarily,
you've always got to watch. Anytime you see a report about trafficking, dig into that report, and you'll almost certainly see the term self-trafficking. Which is the most ridiculous term.
Yeah, which basically every time I go to New York City, I self-traffic.
That's exactly it. It's you moved on your own from one place to another. You were engaged in self-trafficking. And so they'll talk about self-trafficking both in the context of illegal labor, but also in terms of people doing prostitution. They'll say that someone was self-trafficked, and it's like,
how can I convert that into a sovereign?
So you're both a prostitute and the pimp, is what you're saying, Ian.
Yeah.
Well, it's like they'll say Vegas has a high incidence of self-trafficking. It's like people moved there to work at the bunny ranch. That isn't saying that this is, it's not like they were thrown in the trunk of a car or something like that. Right. But it's a way to sort of fake up your numbers to make something into an issue.
That makes me think of like CP on the phone, when an underage person sends pictures of themselves and they're convicted for sharing CP. It's like, doesn't it seem similar?
The horrifying thing about that is that usually when the young person is charged, it's because they tried to figure out who the old person was and they couldn't. So I've seen situations where a young person is groomed online and ends up sending pictures to some person, and they're like, oh yeah, we couldn't figure out who this person was because our investigation ran cold. Let's charge the young person, because then we can get it cleared by charge. And it looks like we solved the case when really we just didn't. We just made another victim out of the whole thing.
Wow. Well, that's a dark thought. So let me see. I want to jump to another story, which is
Merry Christmas.
Let's go to something more calm. And you know what? It is a good Christmas story to the Nate-loving audience. Donald Trump has been removed from the ballot in Colorado, which I know that there are huge swaths that see that as a gift, like Nate. And then there's the rest of us who care about the Constitution and things like that who are offended.
Yes. So I was going to say, Eric, fun fact. Nate was a law clerk who helped advise the judges on this ruling.
That's right. Get him off the ballot.
All right, so I think we need to discuss this in a calm, rational manner. So, Joe,
Let me get a sword.
tell us what's going on in Colorado.
Well, in case you haven't heard, the state of Colorado has the highest court in the state of Colorado, which is a very funny shaped state. If you look, depending on how you look at it, because yesterday I was trying to analyze whether it's a rectangle or not, whether it's perfect rectangle or not, but that's for another day. The state of Colorado has decided that under Section 3 of the 14th Amendment, that Donald Trump qualifies as somebody who has taken an oath and to uphold the Constitution, and then subsequent to taking that oath, engaged in insurrection, and accordingly is no longer eligible to not just serve as president, but even get on the ballot to potentially become president of the United States. Now, the initial district court finding was by the district court, where Judge Sarah Wallace in that case, who's been a judge for all of 14 minutes, came to the conclusion that this section of the Constitution, which has never been litigated in the context of a president before, that it does not apply to a president. But even though, you would think the analysis would stop right there, but so this whole hearing, 5-day hearing that they had, was kind of stupid if it doesn't apply to a president. So it doesn't apply to a president, but P.S. Trump engaged. This was an insurrection, and Trump engaged in insurrection. Her findings were based largely on the testimony of five witnesses and the J6 committee, and heavy leaning on the J6 committee report findings, which that issue alone was hotly contested as to whether or not that's a reliable source. There is an exception for a report that's done independently, and there's a whole test to figure out whether or not that's supposed to be used in this could be used in this context, whether that fits under the exception in this context based on the level of fairness in that report. And that was one of the issues that was highly contested. Now, she originally came to that conclusion. The Colorado Supreme Court came to the conclusion that no, this does apply to a president, and they went through this extensive 100-page breakdown as to why it is that they could justify that this does apply, and that their court, this district court, is an appropriate place for this to be litigated based on Colorado law. There are a lot of now, and that once they reached that conclusion, so then they took her finding that he had engaged in insurrection to say, and therefore he's disqualified and he cannot be on the ballot, and the country properly went nuts. Now, Justice Samauer, who sits on the Colorado Supreme Court, was one of three people. It was a 4-3 decision. Each of the three dissenters gave their own individual bases as to why it is that they dissented. And I thought that Justice Samauer, who went on for roughly 40 or 50 pages, did a phenomenal job breaking down how utterly backward it is to believe that this is an appropriate finding of law. You have to imagine that there must have been extensive conversations amongst these justices as to what the hell are you even thinking here, based on what Samauer wrote. And he's happens to be even though he's Democrat, and all 7 of them are Democrats. Even though he's a Democrat, he wrote such an articulate piece of writing, and with very well thought out reason, and very very engaging language, referring to like the blistering lacuna of issues as to how it is that you could use this simple Colorado electoral statute to try and think that is possibly capable of being used to determine such a weighty issue, when it's only when a weighty issue like this necessarily requires an extensive finding, and this statute specifically says you're not allowed to. You don't have time to have a whole extensive investigation. But one of the points that I felt he made, one of the earliest points I thought that he made, that was really an indictment of this of any of these states trying to go forward with this. And this is something I want everyone who's watching this, who hasn't heard me talk on this before, to understand, that this justice, intelligent, brilliant argument that I hadn't even thought about, is that you have to understand what this amendment is about and then figure out, does it really make sense to use it here? So there's 3 amendments. The 13th, 14th, and 15th Amendment were written shortly after the Civil War. And they were basically trying to figure out, okay, now the North won the war and states' individual right powers lost to federal power. What is going to come out of this? Well, we're abolishing slavery and doing this. But then what are we going to do with these individual states? Like, what's going to happen with these people who just 10 minutes ago were trying to kill us after they swore an oath to uphold the Constitution? And they came up with this 14th Amendment, and part of the 14th Amendment, which there's a lot in the 14th Amendment that we hear about all the time, like whether there's such a thing as substantive due process, but all sorts of different issues with respect to, making sure there's no discrimination anymore, and all these different statutes that we hear about all the time was all part of the Reconstruction era shortly after the Civil War. Well, this part of it here, what Justice Samara pointed out, was basically a fear that the federal government had, that they're like, okay, so this guy who was a captain in the rebel army 10 minutes ago, after swearing an oath to uphold the Constitution, he's going to serve America, he's going to serve our country, and then he basically says, I'm going to go to war against America, and now you're going to put him back in that same position? He's going to be a senator again? He's going to remember the House again? That makes no sense. That cannot possibly be. We cannot allow this. And we have a fear, we, the federal government, have a fear that the states are going to want to send them forward. We have no power under that because our history of federalism is that states can decide who's going to be their leader. So how are we going to stop that? Well, the way we stop that is that we say, if you've done this, you can no longer serve in this capacity. Well, who's going to decide whether or not you've done that? And obviously, that has to be the federal government, because if the states themselves can decide if someone did that, well, then they could take anybody who was a senator before and clearly did insurrect it, and they'll reach a determination, well, we don't think that was really he engaged in insurrection. He didn't really fully engage in insurrection, and send them on back there. So clearly, that right could not possibly belong to the states. And what's happening here is that the state of Colorado is basically saying we're more powerful than the rest of the country and can decide who could be the next president of the United States. That is so exactly, what's our source of that? It's this amendment, which specifically says that federal power trumps over state power. It is so completely backward, and trying to use that element of the Colorado statute is just bizarre. There are other reasons. I've been talking here for like 12 minutes or so I'm going to let some of my other far more intelligent peers speak on this.
Can I make one point to you then, Joe? Yeah. Let me see if this doesn't seem confusing to me. Section 5, the Congress shall have the power to enforce by appropriate legislation the provisions of this article. Yeah, does that mean a town council could do it?
What the majority claimed was that's one option. But as Justice Samara pointed out, it's an interesting thing that I didn't really grasp until I was reading his dissent, is that language of appropriate. Forget about, they could have just said shall put it in legislation. But when they say appropriate legislation, the reason that term appropriate is because the point is that in order to figure out, okay, so now we say if you took an oath to uphold the Constitution and then engaged in insurrection, how are we going to reach this determination? What is the yardstick? Does he have to be found criminally liable? Do you have to have a jury that found that he engaged in insurrection, or could an individual judge do it? What is the burden of proof? Does that have to be preponderance of evidence? Is it clear and convincing? Is it beyond reasonable doubt that this guy engaged in insurrection? What is the yardstick before we're going to take that away from him? So in the amendment, when they're saying appropriate legislation, they're not going to say Congress, that they're going to basically create the framework, the structure, or as Samara wrote in deep eloquence. I was so impressed by his writing, that the scaffolding for how this is going to be structured must be provided for by Congress as to what is the appropriate step. And he actually argues that they sort of did that with what later now we have is 2383, because there is actually a federal statute which says if you engage in insurrection, you cannot serve. And
Well,
Okay, here.
hold on. Can I
ahead.
just, Joe? I want to just add a couple of layers onto what you said.
by all means,
There are two pieces to this. There's the self-actuating piece, and there's the one that Congress has to do. And I think that's the issue that came up in Colorado.
Yeah, that's
Essentially, when the after the Civil War, and then they had the new next election, you had all these Confederates come, and there was like, okay, you guys were Confederates, you guys can't serve. So they made it so they were saying, okay, the ones who were Confederates who had not taken an oath, they could still serve. This was particularly for the ones who had been senators, who had taken an oath to defend and hadn't been. So you actually had a lot of Confederates still who actually served, but they hadn't taken an oath previously not to do it. So what you had here is that, I don't know, the 3 people who were expelled from Congress, those were all 3 because they were already in. So Congress, there's a mechanism for that. But now this was for the people who were trying to get reelected to go back to Congress. This is where they said, we don't want those people to come back. Now, in this particular case, the issue is it self-executing or is it by an act of Congress? Self-executing is if you took an oath and did insurrection, then you can't be on the ballot, versus whether like Southern Law was saying, where Congress has to enforce it in some way or pass some legislation. And the court in Colorado is saying it's self-executing. Insurrection, then you can't be on our ballot. And I think that's the issue the Supreme Court has to now figure out. Is it self-executing, or do we actually have to pass some legislation or some mechanism to go through it?
Where I think Colorado went wrong, sorry,
no, it's okay.
was basing this on the 14th Amendment. Section 3 of the 14th Amendment clearly says, it spells out specifically senators, House of Representatives, other offices. It doesn't name the presidency specifically. And the reason why I don't think it does is if you go to Section 1 of Article 2, talking about the election of the president, the federal government has very little authority other than we receive the electors as selected by the states, and they vote how they vote based on state law. So Colorado could have based this potentially on state law, and there'd be no issue here. We'd be talking about with the Constitution. I think it's potentially the right result, but for the wrong reasons. Because at the end of the day, the states sending the electors, that's all the federal government has control over. We receive the electors for president. Now, we're not talking about Congress or House of Representatives or senators or anything like that. That's all they have to do. And the manner in which those electors are selected and the manner in which, or the way they vote, is 100% up to the states. So I like the outcome, but for the wrong reasons, is where I'm coming down on this. But because they base this on the 14th Amendment, the U.S. Supreme Court's going to have to take this up. And because it's based on the 14th Amendment in combination with Article 2, Section 1, I think Colorado's going to lose at the end of this. I think it's going to be overturned. When you take those 2 sections together, we're talking about a presidency, not a senator or not a representative. I think the Supreme Court is going to overturn this. And I think Colorado did it wrong from the get-go. Maybe they try again.
And Ian, from the Canadian perspective, because this is obviously a burning issue for you up on the hat.
You'd be surprised, actually, because our Canadian politicians talk about Trump a ridiculous amount. Every side accuses everyone of being Trump, whether it's a provincial election or a federal election. It's like, oh, the other side is Trump-like. But I don't like the underlying idea. I'm just like, if the people want to vote for somebody who is an insurrectionist, even if you agree with that, then I don't like the idea of the government getting to pick and choose who runs or who votes. So I guess I take the sort of strong approach on that it's just like, I think the underlying concept is dumb.
The whole question that Nate was bringing up was very important issue in the eyes of the Colorado majority, and also brought up in dissent several times as well, as to whether it kicks in automatically or not. And Justice Samara came up with a very intelligent distinction when he's looking at the 13th, 14th, and 15th Amendments, where he says, look, we're trying to what are they trying to figure out? They're trying to figure out is the moment that they signed the moment that they ratified those amendments, did they automatically snap kick in, or was there further legislation needed by Congress in order for it to actually work? And what the majority reasoned was, well, we see that obviously, it ended slavery right away. It ended discrimination right away. You might need certain specifics to apply it in this situation, that situation, but it clearly became immediately effective. So since that's how it worked with respect to the 13th and 14th Amendments in other ways, how are you going to look at this as being any different? And what Samara put in very intelligently was this: to the extent that the 13th, 14th, and 15th Amendments are broadening civil liberties for people, then that takes effect right away. Because then that's something that they had the power to do. You can say that the government that there's certain civil liberties that you cannot discriminate. That's something that kicks in automatically without the need for further legislation. You might need to have further legislation to address in an employment environment or in that circumstance, but you don't. But it does kick in right away, even without any further legislation. To the extent that these amendments are restricting people's rights, then you can't just say, well, we're just going to amorphously decide their rights are restricted. How? In what way? That's ridiculous. You can't just, people have civil liberties. He has a right, freedom of speech, a right, freedom of association. So if you have these basic fundamental rights, to say that you can even write such an amendment that's going to be restricting people's basic rights without, and we're just going to assume that kicks in right away, even without having any sort of framework as to how that's going to work, is just completely inconsistent with everything else that we understand about the Bill of Rights. So that's why he says that it is self-affecting to the extent it's broadening, and it's definitely cannot be self-affecting, and you do need further legislation to the extent that it's limiting people's rights. And since Section 3 of the 14th Amendment is limiting people's rights, that clearly needed appropriate legislation to tailor how it applies. It's brilliant work. It's brilliant writing.
A super chat here, and maybe you guys can jump in and tell me what it means. Persuasive authority exists, spoken to by Chief Justice Chase directly in the Re Griffin 1869, wherein Chase expressly stated that 14A Section 3 isn't self-executing and requires Congress to invoke 14A Section 5. Is that what you were bringing up, Steve?
That's what the Griffin case was this. So this law was passed in this amendment came into effect in 1868. A year later, Chief Justice Salmon Chase is of the Supreme Court. So he has this case come before him, which is the Griffin case. And the Griffin case was this: Griffin was a charged defendant in a case, and he was found guilty in a southern court. The name of the judge on that case was Sheffy. And what he basically said was, Judge Sheffy served in the rebel army. And he had sworn an oath before the Civil War to uphold the Constitution, and under the 14th Amendment, Section 3, he's not eligible in order to sit as a judge. And since he's not eligible to sit as a judge, how is it that he can come along now and find me guilty? So Justice Chase came in and basically started trying to figure out, okay, so does that mean that all these judges, anyone who's coming in there, that any decisions that they make is that we're going to say the Section 3 is self-executing, and now any governmental powers that are being done by anyone who this may apply to automatically snap, that stops, and they have no power anymore the second that amendment is ratified. And he came to the conclusion, no, it does not. It doesn't make any sense to say that, because we don't know who it's applying to. We don't know if this person it's applying to, that person's applying to. It cannot possibly be self-executing in that way. And that's why Justice Chase came to the conclusion saying that it cannot possibly be. So that's the Griffin case, which came up a lot. The majority tried distinguishing from it and coming up with all sorts of different bases as to why it doesn't apply here. But go ahead.
Hold on, but with the Griffin case, though, he was a judge before the war, right? Then the war came, and
Sheffy was.
So he was a judge before the war. Then the war came, and then he was still a judge after, right? Yeah. And he took an oath for the conservative. But so again, my reading it may be rudimentary, but this wouldn't apply to him because he would have to be impeached, just like those three members of Congress were
What?
All right. So remember, there were 3 members of Congress who served in the Confederate Army. The only 3 people to be kicked out of Congress, like Santos was. But that's because they already were in Congress, and the only way you can kick them out was by the 2/3 vote, and they did that. But now with this judge was already a judge. He already had his lifetime appointment, served in the Confederate Army, and then continued to hear cases when he came back. So in other words, his process to kick him out as a federal judge would be to impeach him, not this self-executing 14th Amendment, just like they did with those 3 congressmen. They kicked them out under Article 1 versus the 14th Amendment. So my reading of that was that this is distinguished because he already had his commission, and now this couldn't remove his commission. The only way his commission could be removed is through a process of impeachment.
I think you're mistaken, Nate.
Okay.
Because the point is, I think you're reading it backwards. The point is, according to the Colorado majority, that this is an automatic disqualification. Now, if you want to undo the disqualification, that's when you need the 2/3. So, so this Judge Sheffy in the Griffin case, the claim that was made is there's an automatic disqualification. So any actions he took as judge don't count. And I am not guilty. I'm not found guilty anymore because his actions were ineffective. It's the same thing. It's the same thing as if my next door neighbor found me guilty. It doesn't matter because he cannot sit as a judge. That the disqualification, as soon as the amendment was ratified, snap, he's no longer a judge. And what Justice Chase said is that's not true. He still was a judge at that point. Because it's not it's not self-executing in the sense that it just was an immediate firing, that they ratified it, and by ratifying it, they immediately fired thousands of people. That was his point. So,
all right. Speaking of firing people, and
fired,
I would definitely personally like to see somebody fired. But here's some advice from Dr. Carol Swain. And people may be familiar with Dr. Swain because she was the source for a lot of Dr. Claudine Gay's thesis that has gotten her into trouble for plagiarism. So this just came out, hold on, okay, I think yesterday. But it is from Dr. Carol Swain, some free unsolicited advice for Harvard University. Number 1, stop listening to the apologists for plagiarism. Number 2, fire Claudine Gay post haste. She can be relieved of duties until the terms are negotiated. Number 3, stop listening to the racist mob of whites and blacks who cry racism while being among the worst offenders. Number 4, hire the best man or woman who can steer the university back towards sanity. Appeasing the Marxist identity politics mob should not be a consideration. The person for the job might be a middle to older age white Jewish man who believes in classical liberalism. Number 5, have a sit-down conversation with the people who have been harmed by the plagiarism of Gay and the system that protects her. Number 6, recognize that Harvard's systematic racism and classism have far-reaching effects. And number 7, apologize to alumni, students, parents, and donors who have been harmed and embarrassed.
Who wrote that?
This is Dr. Carol M. Swain. It was her thesis that Claudine Gay lifted portions from without, I forget, giving the proper attributions.
She's the one Gay chose to plagiarize.
Yeah, but here's the funny.
I don't think she's going to plagiarize that tweet.
Has she been fired now?
No. That's the issue. Is she's still there, and the funny part
Swain.
Is, oh, Swain. I think she's somewhere else. And not
she's retired. She's retired. Yeah.
But one of the craziest accusations is that Claudine Gay lifted the acknowledgments section. I mean,
she plagiarized the acknowledgement sections.
Yes.
Wow. Of all the things that are like low stakes.
Wow.
Yeah, just take it all.
Yeah. Isn't also part of the issue for her too? When you subtract the plagiarized work, she literally has no scholarship she's actually done at this point.
Yeah. Unpublished author. Yeah.
Just like all brunettes, lazy.
What? Where'd that come from? Joe, explain yourself.
Yeah.
Wow.
All brunettes.
It's funny when
I'm a brunette, so there you go.
When this story first came up, there was like only 4, and it was like nothing. But then somebody went and did their work because they really, They tore that
40.
thing apart, and they were like, "Yeah, we're gonna make sure." But I gotta say this though, Harvard, their board of trustees and all the faculty came out again and said, "We stand behind her." And now I think it's gotten to the point where it's just kind of like an FU. We're gonna do what we want to do to the people who we want. You know, it's that type of thing. It's more of I think a rebellion keep than makes any sense, because let's just be clear, if this is anybody else, she'd be gone. But she checks a lot of the boxes, and they feel like they're being pressured. And it's like nobody's gonna pressure
she should
us.
be gone. You talking about Gay for her statements in Congress?
No, they're talking about for the plagiarism stuff and the statements.
For the my whole thing is as they couldn't get her on the whole statement she made in Congress, right? So now they're just going to go after her for whatever else.
Well, yeah, if she's guilty, so what? Oh, it's the same. You could make the argument about Cuomo. Couldn't get him on people in nursing homes, so they got him on supposed harassment, which is falling apart too. But now they want him as mayor for New York City. So I'm very confused about what his actual status is. Is he a good guy or bad guy? I'll defer to Nate on that. All things New York is going to be Nate.
They want him to be mayor again. So
anyway, I just wanted to bring that up. I thought that was a really well worded, thought out tweet. I like a lot of what she was saying about the Marxist ideology. And I think what's going on now is it's like the ideology is so important to that board or Harvard corporation that they're cutting off their nose or cutting off their donors to spite their face. They literally have students, the numbers are down. They've sagged really badly. A lot of students are not committing to Harvard now because of what's going on there. And they've lost well over $1 billion of donor money. Now, I don't know if they may be getting money from elsewhere in the Middle East or something like that could be making up the difference. I'm not sure. But I think it's a very interesting question. And my personal feelings are, I would not mind seeing Harvard becoming an example, sort of like I went to Disney many years ago and enjoyed the place, but I'd be more than happy to see Disney torn up as a corporation and sold in pieces.
What's this going to make other shareholders richer?
That might be, but hopefully it'd be an example to turn some of the narrative around. That's what drives me insane.
Well, I mean, I'm not a huge fan of using legal tools to, at the end of the day, Disney is a corporation and Disney can do what they want with their corporation, whether you agree with it or not. The best way to attack Disney is to not go see their movies,
which is happening,
streaming and things like that. Yeah. Well, yeah. I mean, it's happening more and more.
Well, that's why I said torn apart. I didn't say an outside person is doing it. I'm saying their own actions have destroyed market value to an extreme degree. The parks are empty. I'm not doing that except for not, choosing to not go. So I guess, my presence at the park, many others are choosing that.
Now, what do you think about the government approaches of trying to punish them, though? That's where things get interesting.
Well,
in terms,
I don't like.
If you're taking away benefits that are not natural because they were a large corporation, like the self-governing and the town stuff, there are questions. Are they getting more of a reward than somebody else? And that's a mixed bag. And I can use the same argument.
And
back
if you're
to Harvard.
taking it away to punish speech, that gets into really because then you get the message of, if you cross us by saying something we don't like, then we will come after you. That's where I get concerned, because I've got no problem. Like, if every single person says we don't want to see Disney movies anymore and they go bankrupt, cool. That's the people. Yeah. The government doing it, that's when it starts getting into issues of speech. And I'm much more concerned about a government, because any government that will do that for speech I don't like can also do it for speech I do like. Like,
that's my problem with Miss Gay with Harvard, is that they couldn't get her on the speech issue that they didn't like, and now they're going after her for whatever they can to try to get her out. And okay, maybe let's assume she's guilty of it, the plagiarism thing. How long has that been stewing and nobody did anything until all of a sudden now? That I have a problem with. And whatever action is taken by
hold on,
the trustees of Harvard, I guess it's.
I'm going to push back on that right now, because one question. You're saying, okay, they couldn't get her on this, so they looked at that. Well, maybe this person wasn't noticed. Maybe they're flying under the radar, and they're making these moves. And so you're saying, oh, who the hell is this person? Who is this person that's doing that? And you start to look into them because they've drawn attention to themselves. This could be positive, it could be negative. Jordan Peterson was an obscure professor in Canada. Not people that many knew about him. He was on public television there or whatever. He got caught up in a center of controversy with the Bill C-16. And the people are like, who the hell is this guy? They dug into it, found his YouTube channel, and he became very, very popular. It was a positive effect. Who is this guy? They looked into it. Well, if somebody brings themselves and they rise up above it and stick their head up, the whole thing of don't let your wheat get too high or it gets cut down, the highest stock. Well, are you saying that now there should be a limitation? Like, oh, wait a minute, they only got noticed because they didn't like what they did there.
I don't care if the public does it. I don't care if the public does it. But what I'm talking about is taking some sort of state action against her. That is because you don't like her speech. That I have a problem with. They're calling for her ousting of the presidency and all that stuff because of her rightful position on freedom of speech, in my opinion. But also the I can't remember what else.
Who has the chicken?
I do. I stream above 6 chickens, and apparently they are enjoying the weather today.
Respectfully, gentlemen, you're both wrong.
Okay.
And I'll tell you why. I think you're both mistaken. So, Eric, the reason I think you're mistaken is I don't think she chose to come in there. She was subpoenaed and held before Congress. Yes. So that was not her choice specifically to thrust herself into that role. So in that sense, I don't think that's a fair basis to make a distinction. The reason I think that David is mistaken is because this issue was brought before Harvard 2 years ago, that she engaged in plagiarism. And
hold on, Joe. I'm going to push back on you now, really quickly. Just because she was brought in front of Congress, did she apply to be a president for the school? No. Did she apply to the job? Did she put herself in it? No. Did she put herself in a position to be called in front of Congress? Okay. Now, I will tell you that my wife worked at a university whose president got yanked. Guess what? For lying about their academic background. Mm-hmm. Nobody knew anything about it. The person's walking away just fine. But when he became a president of that school,
I think David's point is that Harvard didn't care. So they did look into her and they didn't care. Now, because she's in the limelight because of the subpoena and her answers before Congress, now all of a sudden people care. But Harvard knew about this and did not care. But that's where I think David. So that's what I think David's point is. But I think David's point is self-defeating. And I don't know.
I'm worried David's hurting the chickens now.
He's there. So the reason I think David's point is self-defeating is this: the whole issue with what her position was is the reason that she's being scrutinized on this issue in the following sense. Ben Shapiro has a 60-second short where he does a great job talking about how Gay is not going to be fired, and the only reason she's not being fired is because she's a black woman. If she was white, we saw the white woman from MIT. She's gone because she's a black woman.
That was Penn. I think MIT still there.
Oh, you're right. Correct. Yeah, you're correct. It was from Penn. Yeah, MIT kept theirs. So the one from Penn is gone because she wasn't a black woman. This woman, the fact that Harvard kept her, despite the fact that they learned of her plagiarism after hiring her, is indicative of the fact that they don't care about what is right. They don't care about what is fair or what is just. All they care about is a social agenda. And they said, she's a black woman, and even though she's engaged in plagiarism, I mean, think about this. Freaking plagiarism is the opposite of what the highest or purportedly highest academe in the land historically in the last 2.5 centuries. There's absolutely no other university. I don't care. You can tell me whatever you want on Yale or Stanford or any other university or William and Mary, and they're all fine universities. And I'm not saying that Harvard is any better than any of them. I'm simply saying that their reputation and the minds of most Americans, you ask them what is the best, most prestigious college in the country, they will say Harvard. And the whole point to academia is teaching people to think and to act, and purportedly to act with some sort of intellectual integrity. And the president of Harvard, the president of the most esteemed education center in the land, has exposed to have violated the most basic precepts of what's proper way of engaging in education. And she doesn't get fired for that. Why? Because there's such corruption as far as that we say that learning and education and integrity, that all takes a backseat to identity politics. And here she comes before Congress, where she basically says, yeah, if they're calling for the genocide of a particular race, if it's any other race, I mean, I guess white people would be in the same category as Jews. But if you said that about Latinos, call for genocide of Latinos, and obviously you would say that that's improper. That should be sanctioned. That should be stopped. If you call for that against Indians or Native Americans or Asians or women or any other, or gay people, can you imagine? They would come down there freaking out. But she couldn't draw that distinction. Why? Because of the same identity politics that kept her in her position.
And maybe kept MIT in there too, Joe, because MIT was Jewish, by the way.
Now, inequitable application of the same rule, I have a problem with. And if, in fact, there are people, let's say there are KKK members marching and calling for the eradication of African Americans, and those people are kicked off campus, and the president of Harvard is saying, those people are not allowed, or it's considered a violation of our policies, which is what the real question was, is this a violation of your harassment policies? That was the question. And if she said yes, but yet in this particular case, the pro-Palestinian protesters were not in violation, then I would have a problem with that. But I'm not going to sit there and necessarily say, because I don't have the whole context. She was asked about a specific group of people, and I agree with the outcome of that, is that freedom of speech is there to protect, as Ian said earlier, speech we don't like, right? And so for that,
it was a code of conduct, though. That's part of it, too, because it was a contractual question. Steve, jump in. I think you've talked about it. Between the students and the teacher, that a code of conduct is not government-protected speech. There are two different things. You're saying, as a student here, you will abide by these rules. Well, and that could be, no shirt, no shoes, no service. Right. That is not speech. It is. And
we'll set the context. Harvard is a private school. It's not
sort of. They get government funding and everything else too.
Well, then certain of the federally protected, constitutional protected rights do apply to them. Am I wrong in that? If they get the federal monies?
I think it depends, and that's where I want lawyers to jump in, because again, you've got a code. So you're saying this is a code, and she didn't say, is this against free speech? That was not the question. The question is this against your code of, quote, bullying and harassment? So my thought is that they should be laissez-faire or crack down on everybody. The consistency angle, I totally agree with you on. But
it was just very specific, and I agreed with the position that it wouldn't be harassment. We don't want to encourage even a code of conduct that would chill people's First Amendment rights, even in that sort of
calling
context.
For genocide. Yeah, okay. That's getting a little.
I mean, but how many Supreme Court rulings do we have involving neo-Nazis and other groups?
Okay,
like
but the neo-Nazis aren't going to class. They're not.
What?
They're not sitting there. They're not beating on the windows, and that's where the thing is. This has gone to another level. And again, if it was wide open and you could say things about people who weigh too much and there's no problem, or you could say whatever you want about LGBTQ, you could say whatever you want, let's replace the word Jew with black. Let's replace the word genocide with an L word that rhymes with wrenching, and then see how it flies. And somebody should ask that exact question. If people are saying that we're going to have wrenching on the campus, is that violating the code of conduct? You know damn well it is. You know that this is. I do wish that they had asked that and lined that up and said, or is misgendering a student considered bullying and harassment? And they have written about it a dozen times over, right? But
see, I want a harassment rule or application that says that's not harassment, because a lot of this stuff isn't harassment. It's hurting my feelings.
Which I agree with that. That's the problem, though, is that they have been running down this particular course, but when it goes a different way, then we don't care. And I think that the double standard is a giant issue, and it should be addressed.
Well, I mean, I am basing it off of her testimony in Congress, and I don't know if there's a double standard because I haven't done my research. But my whole point is that, to me, they should be encouraging freedom of expression, whether you agree with the expression or not, as much as possible. And then again, like Joe said, Harvard didn't care about the plagiarism. That just goes to the quality of Harvard. I would never go there. I would enjoy my kids not going there. Because of a lot of the things going on, but make an example of it. But is it something that we need the state to step in and do anything about? No.
No one, of course, definitely not the state.
How is the state?
Where's the state involved here?
They could say you should be fired, which, by the way, she did in the questioning. You all should be fired tomorrow. You should be resigned. That's an opinion, by the way. That's a freedom of speech by that congressperson. She is not demanding and not making a phone call. Hey, I'm Congressman, blah, blah, blah. Fire this person. She said you should be fired. It's same as I was saying that. So how is that the government stepping in?
Well, I guess when it comes from a congressman, I think more of the state stepping in and trying to encourage it. But
encourage, sure. But a lot of us are doing that right now. I mean, I think that she should be fired. I'm a YouTuber and I'm saying she should be fired. That is my opinion. I'm putting it out there. Do I have any authority whatsoever to Harvard Corporation for her to be fired? No.
Yeah, no. Make Harvard live up to its standards. Yeah, so that I agree with. Make Harvard live up to their standards before giving the president a pass. Yes, the plagiarism thing is a problem, but that's Harvard's problem. The inequitable application of its harassment policies and its quote free speech policies in its handbook and guidelines becomes more than a Harvard problem, I think, especially if they're getting federal funds.
Of course. And that's why there were 3 of them up there that were getting hammered.
MIT, and I don't know what the other one
and
was.
Penn. And the Penn one's gone, by the way. So it's interesting because there were 3 people, one who was white, one who was black, one who was Jewish. Coincidentally, the one who was white is gone with nothing there. The one who was Jewish, MIT, is also there. We don't talk about it quite as much. She's keeping a lower profile. And then Claudine Gay keeps surfacing more and more. And by the way, talking about unequal application, how many people have been removed from Harvard or expelled from Harvard for plagiarism? Can those students now say, hold on,
I would.
I would personally like to see those students come back and say, no.
Yes.
Yeah, I absolutely would.
Yeah. And I mean, but this will just really cheapen their, I mean, it's yeah, I know Harvard, they want to save face so bad, but this really does cheapen their look going forward that they're going to retain her like this. Because now it's like apparently Harvard will condone plagiarism. So it's like, how do I know this person isn't, like the kids that come out of there from going forward?
All a good question. And I don't think we're going to solve it today, unfortunately. So we're going to go ahead and wrap up. Steve has been talking our ear off all day. And Steve, you can keep it short. I'm just kidding.
I just can't wait till it's 5 o'clock here.
Apparently. What do you have coming up, man?
Something going into a glass around 5 today. Working on some very stressful things, and I am looking forward to this weekend kicking off.
I love it. Dave, between your chicken care, what's going on?
Yeah, right. No, I'm going to do a Turtle Boy stream. If you guys don't know Turtle Boy, check him out with Karen Reed case. And then tonight at 7, I'm going to do a little sort of relaxed Christmas stream. So that's what I got going on.
Have you had Turtle Boy on your show or no?
Yeah, he was on actually just Wednesday. He was on, and he's been on a few other times. So he's got some potential new charges and stuff connected with the Karen Reed case and speaking out about that case. And so we'll be talking about that
awesome.
today.
Sean, what do you have going on? Sean?
John's muted. He stepped away.
Mute button. Sean's mute button.
Sorry, I hit the wrong mute button. Tonight, this weekend, will be maybe do something tomorrow night. I'm not sure. But that said, Monday night, if you are sick and tired of your family, by 8:30, I will be on Locals hanging out. And for those of you out there that may not have anybody to hang out with, or people you enjoy, we'll be hanging out on Locals doing a stream. So that's over at Potentially Criminal on Locals.
Okay.
All right. Ian, what do you have going on?
I'm covering a whole bunch of things. I'm going to have a whole bunch of videos coming out about the new gun control laws that were passed here in Canada, as well as I'm digging into some of the there's a lawyer who's suing who's pursuing lawsuits against a bunch of influencers. So I'm going to be trying to dig into that because it's some crazy stuff. Otherwise, I usually stream on Mondays. I don't think I'm going to be streaming on Christmas Monday, but I'll probably do a stream on Boxing Day. So that's kind of my game plan.
All right. And last up, Joe, we always like to hear what Joe has going on, and he usually expounds with a little bit of wisdom or at least some speech.
Hi, I'm Joe, aka Good Lawgic. I take off for Jewish holidays, and I try and make up for it by working on Christian holidays. So I will be working through Christmas and putting out my regular shows, God willing, on Saturday night, Sunday night, probably working around the NFL schedule because it is fantasy football. But I will definitely be putting out work, God willing, probably at both Locals and on, which is at goodlogic.locals.com. That's goodlogic.locals.com, where I basically take the intersection of law and politics and take a philosophical, scrutinizing look as to why we are where we are. So I urge you guys to make sure you check that out. And just as a follow-up here, I want to make clear that while it is that I was basically disagreeing with every person on this panel at some point, not Ian, I think Ian and I we were good, but while I was disagreeing with them, it's the Christmas season. This is the time for us all to get along, for us all to basically come together as one, irrespective of even whether you're Christian or Jewish. That doesn't matter. At the end of the day, this is about humanity coming together, and whatever helps invoke